all sorts of coercive recovery. So as I said, the notification of 29/5/2015 it mandates or it obligates on the part of banks and financial institutions to identify incipient stress before an account is classified as NPA, thereafter proceed to constitute a committee, and the committee is just akin to that of a committee under the BFR or even under the current scheme under the IBC. Then it has to make a viability study, make sure that the company, the MSME, it has to ascertain whether it is feasible to come out of the incipient stress, and if it is once is found it is feasible to revive the unit, then committee is empowered and competent to direct the banks and financial institutions to put in further inflow, even in respect of a entity which has become non-performing. Then if it is not possible to revive, then the committee is empowered to permit and suggest and decide upon the means of recovery, the method of recovery also. So therefore, once the committee decides, then the MSME is not feasible to revive it. There is no other option than to permit recovery. Then the banks committee can permit recovery under the SARFAESI Act. It can permit recovery under the Recovery of Debts and Bankruptcy Act. And then this is one aspect of it. Second aspect is, even where the borrower, even before any kind of recovery steps are initiated against him, even before this account is classified as NPA, or after the accounts are classified illegally classified as NPA without a constitutional committee is being constituted at any stage, before the net worth is not more than 50% of the net worth is eroded, the borrower can make a representation to the committee for a constitution of a committee, make a request that a committee be constituted. So what is the relevance of the limitation is that such a request shall be made before 50% of the net worth is eroded. There is a reason behind it. If the accumulated losses is more than 50% of the net worth, then it is not feasible to revive the unit. So and therefore that is the only limitation. So therefore it is incumbent upon banks and financial institutions to constitute a committee, and the committee to consider the feasibility of resolution of stress, and while the committee is in season or in ceased of the resolution process, no form of recovery by any authority could be allowed to be permitted. So therefore the limitation is under SARFAESI Act, the bar is not to without constituting committee before an account is classified as NPA, the bank and financial institutions has to identify the incipient stress and constitute a committee, and then committee can classify the account as NPA. But classification of account as NPA will not necessarily mean permission to proceed to recovery. So the committee is empowered to classify an account as an NPA. That's the reason behind it, because it's a fundamental principle that banks and financial institutions, the financial statements should disclose the true state of affairs. If the MSME is in a bad shape, of course it has still a possibility of recovery, but it may not be in a situation where the entire debts could be recovered by a bank or financial institutions. Therefore, the banks and financial institutions should be allowed to classify the account as NPA and make provision for bad and doubtful debts. So therefore, this scheme is intended for keeping the interest of the banks, primarily I would say, keeping the interest of the banks and financial institutions largely in mind. So too the MSME. It is not a scheme which is against the banks. It is a scheme which is intended to be implemented by the bank. It is a scheme, while being one benevolent or a welfare legislation intended to reach out to the MSMEs, it still takes care of the interests of the banks and financial institutions, because interests of the banks and financial institutions no government can ever ignore. So what is contemplated is, yes, before MSME shall not be allowed to fall sick, and if fall sick, If there is it is feasible to revive, then it should be administer the medicine, and it should be allowed to regenerate and retain robust health, and if not possible, allow it to be liquidated.